All right, y'all, welcome back to the show. It's Antiwar Radio. Chaos. RadioAustin.org, LRN.FM, AnomalyRadio.com. And Elaine Cassel is on the phone. She's the author of The War on Civil Liberties and is a civil rights attorney. I think in Washington, D.C., right, Elaine?
That's right, in Virginia.
In Virginia, okay. And so I wanted to start right now, as hopefully I can sort of work a segue from the last interview. Just finished wrapping up with Andy Worthington, and he talked about how so many of these people were tortured and accused and kidnapped and hooded and God knows what, based on things that were beaten out of Abu Zubaydah that were never true in the first place. And Abu Zubaydah, of course, was not a dangerous terrorist, but was a travel agent for Zawahiri or whatever, and knew a bunch of guys. And anyway, it reminded me of the story of Binyam Mohamed, the Ethiopian, who was tortured. And in Morocco, it was revealed that they tortured him with razor blades, including on his, the parts that you would least like to have cut with a razor blade by a Moroccan CIA torturer. And he made up the story and pointed the finger at Jose Padilla, which is one of the most outrageous abuses against the law and individual and Americans' rights in the history of the United States. And it was all based on lies that were tortured out of this guy, Binyam Mohamed. Now, he's free in the United Kingdom, but was seeking some justice in the American court system. And then the Ninth Circuit Court, which, Elaine, as I understand it, is the nicest one, the leftist one when it comes to civil liberties issues in this country, told him that he wasn't even allowed to introduce unclassified material about what happened to him in order to get any justice. Because I guess, King Charles rules and he's got sovereign immunity, and that's the end of that. Is that basically the rules, or what? How does this work?
The law is that a judge can refuse to let any case go forward if, quote, state secrets, end quote, might be revealed. And state secrets have been broadly construed, the term, to mean virtually anything you want it to mean, including the weather report. So it's just a blanket grant of secrecy, and further, the law does not require, although it allows if a judge wants to, but it does not require a judge to inquire in his or her chambers what the alleged state secrets are that would be disclosed. And so judges who want to have a great mechanism for clearing their docket and not hearing a case by just saying, state secret, that's what the government says, case closed. An occasional judge has said, okay, prosecutor, come and tell me in secret, whisper in my ear what the alleged state secrets are. And in those cases, routinely, the judge will say, oh, okay, defendant, state secret, I'm satisfied, case closed. So it's just, it's a horrible abuse. It's a great way to totally get the government off the hook and get judges off the hook. And it's just a travesty. A travesty of just to show you that there's very little justice when it comes to people that have claims against the government. There's very little justice in the criminal justice system.
Well, now, Elaine, you seem to be saying that the judges, they're just in a hurry. They just don't want to bother. But, I don't know. Federalist Paper number 10, right? James Madison says, look, everybody's some kind of SOB or another. So what you got to do is ambition must be made to counteract ambition. We'll have the incentive structure set up where the judges get their thrill by making life miserable for the executive branch. And that's how they get to be powerful, is to say, no, government, I'm on the side of this little guy against you, screw you. That's what's supposed to make a judge, the independent judiciary and all that. And yet, nah, they're really just part of the federal government like everybody else, I guess.
Well, of course they are. I mean, they're federal employees, and they have life terms, and they can do whatever the heck they want to. Absent some gross misconduct, they're not even going to have impeachment trials. Well, there is an interesting impeachment trial going on right now in Washington in the Senate against a federal judge, which is rare, but it has to do with, financial issues. It's nothing that has to do with justice. And you could never bring a judge up on charges that they didn't do something right in a case. They have total immunity. A judge has absolute immunity from suit for anything that they do in the course of being a judge. Now,
even if he outright conspires with the prosecutor and the cops to frame up an innocent person.
Absolutely.
She said.
A judge has absolute and total 100% immunity from anything done that is remotely connected to their job as a judge. Now, if they are accused of taking bribes, a financial thing, the law accepts that a judge should not take bribes. But if a judge moves the case along, interprets evidence a certain way, rules this way or that way about something, whether it's torture or not, absolutely no suit. I had a case that went to the Fourth Circuit where I sued a local judge who actually went out and told the cops to arrest a woman in town on trumped-up charges, a woman against whom this judge had a personal vendetta. And when I got to the Fourth Circuit, of course, I lost in the district court in Alexandria. I took it to the Fourth Circuit, and only one judge voted on my side. The case decision, which was reported and written up in the books, was that, quote, although we don't really think what this person did was right, what she did was a judicial act. She signed off on an arrest warrant, and that's what judges do. So irrespective of the fact that she instituted it for personal reasons, the case was lost. So that immunity, by the way, extends to prosecutors. Prosecutors have absolute and total immunity from suit. Now, for instance, you remember the lacrosse rape cases from Duke?
Absolutely.
Where the charges were trumped up? Okay.
Yeah, and just for the audience, Elaine, let me say real quickly, they might remember William L. Anderson at LouRockwell.com and at his own site was on that case from the get-go, and there's a wonderful chronicle of just how horrible that thing was by William L. Anderson. Just that's the name, and lacrosse, and you'll be filled in for sure.
Okay,
I'm sorry, go
great.
ahead.
Well, so what happened as a result of that is, of course, you couldn't sue the prosecutor because he could bring whatever charge he wanted. He had a witness who, made all this up, but so what? The law says he can do that. He did lose his law license, okay, because the state bar of North Carolina found that, I guess it was such an outrage in Duke, by the way, even though Duke had, first of all, just thrown these kids under the bus, and but then, to sort of spare the embarrassment to the institution, I think North Carolina kind of said, okay, we got to do something about this rogue prosecutor. In a way, you see, that kind of got Duke off the hook, because you remember not only did Duke canceled that whole season, and by the way, I know something about this because my grandson plays lacrosse, and not only that, but the NCAA sanctioned Duke that year. And now, as a result of that, the NCAA has had to cut Duke some slack in recruiting because everybody just went along with this prosecutor. So, but bottom line...
Nifong, that was his name, the rat.
Okay,
here.
That's correct. But you couldn't sue him. In other words, the kids can't sue the prosecutor for what he did.
And again, that's why I wanted to really emphasize William L. Anderson's work on this, because Nifong was acting criminally here. He wasn't wrong. He had a criminal conspiracy to destroy the lives of innocent